The advisory guidelines at 0 to 9 on a felonious assault, 4-year maximum, and child abuse fourth, a 1-year misdemeanor. Counsel, you want to state your appearances for the record, please?
Melissa Goodrich, Boyne County Prosecutor.
Brian Henry, Eric Gauthier. He's a counsel here with no right assistance.
Thank you. I would note I have received some letters of support for Mr. Gauthier and received and reviewed those. Have you had a chance to review the pre-sentence report with Mr. Gauthier?
I have.
Do you have any additions or corrections?
Other than what we've already supplied to the court, we don't have any additions or corrections.
Any scoring challenges?
No, it seems to be scored properly.
Ms. Goodrich, any additions, corrections, or scoring challenges?
No, Your Honor.
Okay, Mr. Plain, anything you want to say on your client's behalf?
This isn't just another sentencing hearing. This is a case where rehabilitation clashes head-on with accountability. A defendant accused of violent domestic assault, a victim demanding justice, and a judge forced to weigh progress against a deeply disturbing past. Will efforts to change be enough to avoid serious punishment? Or will the court decide that some actions demand consequences no matter what? Stay with us, because this courtroom is about to deliver a decision that raises a bigger question. Can someone truly change fast enough to earn leniency?
Yes, Your Honor. So I've been working with Mr. Gauthier on this case for several months now. Of course, aware of the age of the case. It's not an old case, but one of the reasons or one of the things I tried to accomplish when I was working with Mr. Gauthier is identifying, first of all, that there's a problem. That's how we start solving every problem. So we identify there's a problem. So obviously I'm not a clinician, but I reached out to some that I work with, the Galinskis, and I said, I wanted Mr. Gauthier basically screen for every possibility. I want to screen for anger management, domestic violence management, alcohol management, everything. Because I wanted to see the whole plan that I had was, I thought that the best way to tackle this issue is to try to demonstrate to the court that Mr. Gauthier wanted to make positive changes in his life. It's not unique. I've done this before. What is unique is the fact that I've never, in many years of practice, had somebody who embraced it in the way that Mr. Gauthier did. The reports, the updates, the number of classes he's gone to, the individual counseling. It's not a magic bullet, but what it does do is it demonstrates to the court that Mr. Gauthier is making positive changes. And so I did receive a lot of letters talking about that Mr. Gauthier is not a good person, and I recognize that. Matter of fact, I recognize historically that what happened this day was a horrible thing that happened. But there's only one way that Eric could deal with it, and that's to go in a positive direction. And sometimes until you really dig deep in, you don't realize that you need help. In talking to both Chance and Alice Galinsky, in reading what they had to write about him, and the amount of effort he's put in with the men's group, the individual counseling, it inspires me to think that this is not superficial. I want to look good for the judge. I think this is, I want to be a better partner. And I fully recognize and make the statement that Mr. Gauthier and his wife's marriage is ending. I get that, but they still have to be able to communicate and get along because they have young children. And I thought, well, geez, if he's going to be the best father, and I've had this discussion with the court that, I try to inspire my clients to be the best version of themselves they can be. Mr. Gauthier, admittedly, was not the best version of himself. Matter of fact, he was quite a horrible version of himself, if you believe everything that's in the letters in the police report. But I think when he recognizes the wrongfulness of his actions and seeks to rectify his behavior, not wanting the rest of the world to change around him, but for him to change the rest of the world, I think it shows a lot of growth. So when I look at and I think of the 4 goals of sentencing, rehabilitation, protection of society, punishment, and sending a current message to others, I always kind of default that if I was a judge, if I was sitting in your position, punishment might be really important. Maybe it wouldn't be. But what would definitely be really important to me is protection of society, because I have an obligation as a judge to make sure that people in society are safe. That's one of the things the judges do, and I think it's a very important role. If a defendant has engaged in rehabilitative services, in rehabilitative counseling, and is doing more than just the superficial, just getting by, not throwing up reports like Mr. Geyer of excellent participation, good progress, excellent attendance, regular and consistent attendance. I think, although it does help Mr. Geyer, I think it also helps the court understand that Mr. Geyer is making positive change. He could sit here and he will say he's sorry, and he's really sincerely sorry, but that falls so much on deaf ears, because you and I, as officers of the court, you as a member of the bench, we can't sit here and extrapolate in our minds and imagine in our minds what the relationship between the Geyers were, other than to say that it wasn't good. And the blame can probably be assigned in large part to Eric's conduct, his anger management. And my point in kind of going on about this issue is I want the court to know that sincerely, Mr. Geyer, and I've had a lot of conversations about this, and I think he sincerely wants to be a better role model, a better parent, better partner, better co-parent. And only after he deals with himself and his shortcomings can he even begin that process. I'm fully cognizant of the fact that there's a divorce pending, and that there's going to be a child custody determination, and whatever it is, there's going to be some level of talking, getting along, and I just want Eric to be the best he can possibly be. The only thing that concerned me, and I discussed with Eric, he's going to address it with the court, was I kind of took his defendant's description of the events as minimizing and blame shifting. When I talked to him about it, I said, I don't like that at all. And he said, I did not use my words properly. He said, I told her, the agent, I take full responsibility for what I did, that Brittany has no responsibility here with regards to what happened. And he said, that's not how I feel. He said, I've learned stuff, I've learned new tools in my counseling in order to better communicate. So I look at and there's no jail time recommended, but of course I want to address that issue. Because I'm fully cognizant of the fact that the prosecution are probably asked for jail time. I'm going to describe to the court why I don't think that's necessary in this case. We got a guideline scoring range of 0 to 9 with somebody with no prior record. So we already have an intermediate sanction and a low intermediate sanction at that. And not only that, but on the 0 to 9 range, Mr. Geyer is also admittedly lower on the scale. So the proportionality, I think, would push towards no for incarceration. I do recognize that the court said the focus of my sentence is going to be punishment, not warrant incarceration. The reason I would ask the court not to consider that is a more of a practical one. I don't want Mr. Geyer to slide backwards. I want him to keep pushing forward. I don't want to miss one men's group. I don't want to miss one individual counseling session. I don't want to miss any of this because he's going forward. I fear that if he had to even go sit for 30 days, that would push him back. Now, I'm not saying that the court deems that that's what's appropriate, that Mr. Geyer isn't going to do it and do it with a smile on his face. My concern is I just want to see him making forward progress. If he had come in, or Mr. Galinsky or his wife had sent in reports where he was just barely doing the minimum, and he was kind of showing up to meetings when he wanted to. That's not what I'm reading at all. So I think a probationary sentence to reinforce and to monitor Mr. Geyer's continuation with completing the men's group. He's 21 sessions in out of 39. But rather than incarcerating him, I'd ask the court to consider a probationary sentence. I fully recognize this is obviously the court's purview to do what you want to do. But I think that we've given the court as much information about Mr. Geyer. We supplied letters of support for him. I've surprised his counseling notes. I've tried to give the court everything I can possibly give you to persuade you not to give Mr. Geyer jail, but to persuade you that he is making an honest effort to be a better person. So I know Eric has a prepared statement that he wants to present to the court.
Okay, thank you, Mr. Klingon. I guess I do want to just clarify one thing for the record. I did receive and review the letters of support for Mr. Geyer. And because he's a litigant to the case, the defendant and his liberty interests are at stake, he's entitled to present character witnesses. I was presented with some letters that upon initial glance were apparent to me that they were from supporters of the victim and making claims obviously negative to Mr. Geyer, and that they contain some sort of substantive claims as well. When I noticed that that was what it was about, I did not read those letters at all, because I don't think that that's a proper way for me to consider information at sentencing, because the defense has no ability to cross-examine that information. The victim's not a direct litigant to the case, has certain rights under the Crime Victims' Rights Act that are afforded, including making a statement on her own behalf. But for the court to open it up for just letters from the community negative toward a defendant, I don't think, I think that would violate the defendant's due process rights. So I did not review the substance of those letters. All right, Mr. Geyer, you don't have to make a statement today, but you're allowed to. Is there anything that you want to tell me, sir?
Yes, sir. So thank you for giving me a chance to talk today. I want to begin by saying how truly sorry I am for my actions. From the moment that it happened, I deeply regretted it. I knew it was wrong. I've carried that with me every day since then. I take full responsibility for my behavior. I'm not here to make excuses. Over the past almost 7 months, I've had a lot of time to reflect, not only on what I did, but what I've lost. I missed so much time with my children, and including a lot of first with my youngest daughter, who was an infant at the time it was happening. Those are all moments that I can't get back. That pain, that absence has been one of the hardest things that I've had to endure through all of this. It's been one of the strongest motivators for me to change also, to be better, not just for myself, but for my kids. Since then, I've made a commitment to do the deep, difficult work of bettering myself. I've been actively involved in both individual therapy and men's group for anger management. I'm learning how to manage my emotions, understand my triggers, and navigate them in a responsible way. I've also been reading and watching a lot of self-help literature, including resources from Jordan Peterson, amongst a lot of others, which have helped me shift my mindset and take ownership of my life. I'm working every day to build stronger coping skills and emotional regulation, not just to prevent future mistakes, but to become the kind of father and person that I want my children to look up to. Your Honor, I don't stand here today looking for sympathy. I stand here to show you that I'm taking real steps toward lasting change. I'm not the same person I was 7 months ago, and I don't intend to ever be that person again. My children deserve a lot better, and I'm doing everything I can to give them to them. Thank you for your time and your consideration.
Thank you, sir. Ms. Goodrich, any recommendations?
Yes, Your Honor, I would ask the court to allow Brittany Geyer to make a victim statement.
Yes, Ms. Geyer, if you want to come forward to the podium here. Good afternoon.
Your Honor, my name is Brittany Geyer, the soon-to-be ex-wife of Eric Geyer. I never imagined myself standing here speaking these words and reliving these moments. But I need you to understand what I have endured, not just for myself, but for my children and for all the women who have been in my position. On November 27th, 2024, my life took a turn I can never forget. That night, I had just come home with my children. It wasn't long before another argument started, something that had become painfully routine. I was tired, desperate for help, and frustrated with his lack of support. He was angry over things that seemed so insignificant compared to the weight I was carrying. As I stood there holding our 6-month-old daughter with our 5-year-old son nearby, Eric began to shout in my face. As he went to finally walk away, he grabbed a freshly opened can off the counter and slammed it in the sink, causing it to splash all over himself. Then, without warning, he turned around and grabbed me. Both hands around my neck, he lifted me off the ground, ignoring the fact that I was holding our baby. My son stood behind him, begging him to stop, but he didn't care. He carried me and my 6-month-old daughter toward the front door, squeezing tighter. Before we even made it there, everything went dark. I blacked out. When I came to, our daughter was face down on the floor. I still replay this moment in my mind. The way I struggled to process what had happened, the way I feared for her, the way I feared for myself. Thankfully, she wasn't seriously hurt, but I strongly believe the only reason Eric let go of me that night was because she fell. If I hadn't have dropped her, I really question if I would be here today. That was the moment I knew I could never let this happen again. This wasn't the first time. On March 28, 2024, while I was 8 months pregnant, Eric strangled me during another violent outburst. That night, he also smashed my phone onto the tile floor. His anger has put me and my children in danger more times than I can count. Since that night in November, I moved out, taking my children with me. I have been supporting them all on my own. Eric contributes only half of daycare costs. For a short time, he offered slightly more toward my weekly daycare expenses, but not for long. In that last 7 months, the only other support I have got is about $100 beyond that, forcing me to bear the financial strain on top of everything else. His aggression has not stopped. Just last month, he got into another altercation at work. Before that, he was fired for harassing a coworker over the course of 2 years. His actions show a pattern, one that does not start or stop with me. I am not at all the first person that has called or he has been here for. Yet, despite the danger he poses, his charges have been drastically reduced from his original arraignment, even though the court initially ruled that he was a danger to the community. I am not the first woman he has hurt, and yet the leniency of his sentencing recommendation is exactly why women stay silent, why they fear leaving, why they hesitate to come forward, because too often abusers walk away with little consequence. This is more than just my story. This is about accountability. This is about setting a precedent that says violence like this will not be excused or dismissed. This is about protecting the next woman, or the mother, and the next child from enduring what I did. I ask the court to recognize the full weight of this case, the physical harm, the emotional trauma, the financial hardship, and the lasting fear. These things do not disappear once the courtroom empties. My children deserve safety, I deserve peace, and justice should reflect the reality of what happened. I would like to see jail time in his sentencing. Thank you.
Ms. Goodrich, any recommendations from the people?
Yes, Your Honor. The defendant is 43 years old. He has no prior felonies and 1 prior misdemeanor. He's employed with a high school diploma. As the victim, Ms. Geyer, has stated, as to what occurred on November 27, 2024, I know that the court is trauma informed and realizes that a strangulation the next time around the domestic violence wheel can often lead to death. He does have a prior 2008 domestic violence incident. He received 6 months probation there. There were some red flags in the PSI briefly addressed by Mr. Clayhoom that he still blames the victim, that despite the positive reports from counseling during that interview, at least he downplayed the offense. He had a 2017 case, domestic violence case that was dismissed. And here we are in 2024, and this time it went from interfering with electronic communication and domestic violence in 2008 to now 2024, felonious assault with a child abuse fourth due to the child being present and dropped based on the victim being choked. I do recommend some jail time, as Mr. Clayton stated that I would, because deterrence and due to the deterrence and punitive nature of sentencing, and would ask that the no contact remain in place.
All right, thank you. Mr. Geyer, if you please stand for the first sentence. Mr. Geyer, you're 43 years of age. You have no prior felony convictions. You have one prior misdemeanor from a domestic violence incident back in 2008, where it was a plea to attempted interfering with electronic communications. Your attorney outlined some of the mitigating factors of after the fact and the rehabilitative efforts that you've made. And the prosecuting attorney has outlined some of the aggravating factors that led up to and included this incident. And so this court's got to balance, the truth of both sides of that for what's an appropriate sentence here. And, when I look at this history, you've got two prior arrests for domestic violence. One resulted in a conviction, one was dismissed. I don't really know anything about that, so I can't completely assume that, you committed some wrongdoing there, but I've been involved in the justice system long enough to know that there's lots of reasons why those are dismissed, and it's not always because the defendant didn't do anything wrong. In fact, for domestic violence, I'll tell you, it's not often that way. And what you need to know is this: most men make it their whole lives, Mr. Geyer, and never once get arrested for laying hands on a woman. It's not that hard to take that path. Yet you have repeatedly taken a different path. The prosecutor's right that there's an escalation here from a 2008 domestic violence to now one that did involve, even by your own admission, grabbing someone by the neck. That's a troubling escalation. That's not even the most troubling thing to my mind, that you're doing that while the victim is holding your vulnerable child. It seems that alcohol has played some role in your lack of governing yourself. And you're kind of shaking your head no, but was alcohol even involved in this incident? Okay, sure. Okay, well then, clear-minded, realizing that, I hope at some level you're experiencing some sense of shame at that conduct. Really, who does that? Grabs their wife by the neck while she's holding your infant. In the prior cases, even the one that resulted in a conviction, you were given probation. So it looks like you never really did any jail. If everything that Mr. Klain has said today is, he's doing a great job for you, of course, and everything he's saying today would certainly cause me to follow every drop of his recommendations if I was the judge back in 2008 looking at a first-time domestic violence offender. But this is not your first time of domestic violence. And this was in the world of the domestic violence cases we see, none of them are acceptable. Some of them involve a shove, even a threatened striking someone, but not actually striking them constitutes a domestic assault. So when I think about the continuum of a domestic assault, this is more on the extreme end of it. There's certainly, I'm not overstating that, there's certainly, to be sure, more extreme domestic violences that we sadly see where there are injuries and broken bones and all sorts of horrific things. But I just say that to place it in context that this was a serious event. And the fact that you placed a child at risk of harm is a significant aggravating factor that I don't even think, honestly, if I were, I'm not looking to do this, but honestly, the guidelines wouldn't adequately take into account. It just takes into account that, somebody was placed at risk of harm. But the degree that a young, vulnerable child was placed at risk of harm aren't even taken into account there. So when I try to balance what's a proportionate sentence here, I think a term of probation to make sure you follow through on these rehabilitative efforts is appropriate. So I am going to place you on probation for 2 years, subject to the terms and conditions listed on pages 2 and 3. I want to highlight some of those conditions. You have to complete the mental health, domestic violence, batterer intervention, or other recommended treatment as recommended by your supervising agent. You may not have any contact whatsoever with Ms. Geyer, consistent with the details of that term laid out in the pre-sentence report. As you guys navigate through a divorce and parenting issues, perhaps there could be some way that can change down the road while you're on probation. I don't know. But for right now, that's what she wants, and that certainly is appropriate. So we're going to make that a condition. You have to seek and maintain full-time legitimate employment. There's a crime victims assessment of $130. That's fine. You can remain seated. There's a crime victims assessment of $130, court costs of $350, state costs of $118. You have to comply with DNA testing and pay a $60 fee. There's also a monthly supervision fee to the Department of Corrections. And I do think that some jail is appropriate, even though it's an intermediate sanction. The prior domestic violence conviction and the risk of harm to the infant are reasonable grounds for jail, despite the fact the guidelines are intermediate jail sanction. When I consider how much jail is necessary, I can make a good pitch for the 9. I could make an easy pitch for 6 months if I'm only thinking about, say, deterrence toward others. But I also have to take into account the efforts that you did make, your lack of prior record, your lack of prior incarceration, so that I don't think an extreme amount of jail is necessary to kind of give you a shake by the collar and wake up call. And so I am going to order that you serve 3 months in the Sheboygan County Jail with credit for 6 months, credit for 6 days previously served. Within 24 hours of your release, you have to contact your supervising agent. I would indicate that I have no objection to your participation in any CBT programming in the jail, any counseling programs in the jail, and you can earn a little bit off your sentence in that regard as well. And Mr. Geyer, you can file an application for leave to appeal if you wish to challenge your conviction or my sentence or both. If you wanted a lawyer appointed and qualified, you'd have to make that request within 6 months. We're going to hand you a piece of paper about the appellate rights, ask you to initial one copy for us, and the other one is for you to fill out if you want to take an appeal. Do you have any questions for me, sir? Okay, good luck to you.
John,
Yes.
The program the court authorized him to do, does that include any kind of work release programming or?
It doesn't. Is he employed right now?
Yes.
Okay, I would also indicate that work release for 40-hour work week would be allowed. So you'd have to work that out with the jail administrator, whether you're eligible for that program based on the offense, that you have to get them your schedule and documentation, and they have to approve you. But I'll indicate that the court has no objection.
Okay.
Mr. Clem, does that include your matters?
It does.
Okay, you have good.
Good night.
In the end, the judge delivers a balanced but firm sentence. 2 years of probation, strict conditions, no contact with the victim, and 3 months in jail despite guidelines suggesting a lighter approach. That decision tells us a lot. Yes, the court recognized the defendant's efforts toward rehabilitation, but it also made it clear that serious violence, especially involving a child, cannot go unanswered. This case highlights the core challenge of the justice system: protecting society while still leaving room for personal reform. And now we turn it over to you. Do you think this sentence was fair? Too lenient? or too harsh given the circumstances. If you found this case as intense and thought-provoking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.